A declaratory action may be taken as a judicial order issued by the court declaring rights of the parties without giving any further relief. Thus, a declaratory decree declares the rights of the parties. In such a decree, there is no sanction, while an ordinary judgment prescribes some sanctions against the defendant. By declaring the rights of the parties, it removes the existing doubts about the rights and secures enjoyment of the property. It is an equitable remedy. Its purpose is to avoid future litigation by removing the existing doubts with regard to the rights of the parties. It is a discretionary remedy and cannot be claimed as a matter of right. According to this myth, the power of a court to render a purely declaratory judgment is particularly valuable in cases where a legal dispute exists but where no wrongful act entitling either party to seek coercive relief has been committed. By making an order declaratory of rights of the parties, the court is able to settle the issue at a stage before the status quo has been disturbed. Inconvenience and the prolongation of uncertainty are avoided. Many questions of personal status and title to property and matters arising out of the interpretation of will, trust, contracts, and other written instruments cannot appropriately be determined by the courts except by means of a declaratory judgment. In administrative law, the importance of resolving doubts is no less obvious. A public authority uncertain of the scope of powers which it wishes to exercise but which are disputed by another party may be faced with the dilemma of a discharging its responsibilities unless it is able to obtain the authoritative guidance of a court. By bringing a declaratory action, it is equally for the public benefit that an individual whose interests are immediately liable to sustain direct impairment by the conduct of the administration should be able to obtain, in absence a judicial declaration of the legal position. A declaratory judgment differs from other judicial orders in that it declares the law without pronouncing any sanction against the defendant. Section 34 of the Specific Relief Act deals with the declaratory decree, but it is not exhaustive. The court may grant such a decree independently of the requirements of Section 34 of the Specific Relief Act. Apart from that section, the courts may grant declaratory decree so as to declare an administrative action or statute ultra-virus without giving any further relief under Article 32 and 226. So, according to Section 34 of the Specific Relief Act, any person entitled to a legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. A trustee of property is a person interested to deny a title adverse to the title of some one who is not in existence and for whom, if in existence, he would be a trustee. So, according to Section 35, a declaration made under this chapter is binding only on the parties to the suit, persons claiming through them respectively, and where any of the parties are trustees on the persons for whom respectively, and where any of the parties are trustee on the person now for whom, if in existence at the date of the declaration, such party would be trustee. So, for maintaining a suit under Section 34 of the Specific Relief Act, certain conditions are required to be fulfilled. And those conditions are: the first one, the plaintiff must be entitled to a legal character of or right as in any property. Legal character may be taken to mean a statute recognized by law. It includes every judicial or jural relationship which is recognized by law. It includes the status of a person and situation where a legal right of a person is violated or threatened to be violated by an illegal action of the administrative authority. Thus, a declaration can be sought by the plaintiff that his nomination paper at a municipal election has been illegally rejected as it was decided by the Lahore High Court in the leading case Satnarayan versus Hanuman Prasad. The term right as to property is used in broad meaning. It does not mean merely actual right in the property. A rate payer of a municipality can file a suit for declaration that the sale of municipal land by the municipality is against law because the rent payer has special interest in the municipal property. So also, There must be some person denying or interested to deny the legal character to which the plaintiff is entitled or right as to any property to which the plaintiff is entitled. Such character or right thus must be questioned. So section 34 makes it clear that any person entitled to a legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right. For this purpose, a mere threatening of denial is sufficient. So also the plaintiff is required to seek further relief if it is available. Its object is to prevent the multiplicity of suits. For this purpose, further relief must be the relief which directly flows from the declaration and available in the same proceedings. If the plaintiff is entitled to consequential relief but does not claim it, the declaration will not be granted by the court as it was decided in the leading case, Buddhu Singh versus Board of Revenue in 1957 by the Allahabad High Court. So declaratory relief is a declaratory remedy. The court may not grant a declaratory relief if it appears to the court useless. It may also be refused in case other appropriate or alternative legal remedies available to the plaintiff as declaratory action is a statutory remedy and therefore it may be excluded by this statute. Before a suit for declaratory relief is filed against the government, 2 months' notice under Section 8 of the Civil Procedure Code is required to be given. Declaratory remedy has certain advantages also. It is a simple remedy and can be obtained from the lower courts. It is cheap compared to the expense of rate which can be obtained from the high courts or the Supreme Court. And regarding action for damages, exactly if any injury is caused to an individual by wrongful or negligent act of the government servant, the aggrieved person can file suit for the recovery of damages from the government concerned, and that we found under the liability of state or government under tort, so also liability of the state and government under contract, and those portions relating to liability of state and government in contract and in tort we would like to discuss in another upcoming video.